After 7, my name is Kobby Spiky Nkrumah, and you're tuned in to Joy 99.7 FM. And on Tuesdays, when you hear this voice, then you know we're about to talk technology. And today, we're not just talking about, bits and bytes and megahertz and gigahertz and the cloud and all that stuff that confuses a lot of people because of the terminology. We're talking about anything and everything that could concern everyone. Intellectual property. And if you don't know what that is, it means that you probably don't know what you're doing with your own creativity. You're just giving out your skills for free. Are you a creative person? Have you ever created a TikTok video? Have you ever posted something on Instagram that you created? And I'm stressing on you created because it has to be yours. That is your intellectual property. And if you're a musician, or if you're a creative person, or you're even an inventor, because we can't leave them out. This conversation is for you because that creation, whatever it is that you've created, is your intellectual property, and how you guard it is what we're about to discuss. And today, joining us is a very important person. She's a lawyer in intellectual property. She goes by the name of Madam Sarah Noko Anku. Welcome.
Thank you.
And I'm joined by Winston and Michael.
Hey. Greetings.
Yeah, Michael feels left out because everybody sitting at this table has twists or dreadlocks or some kind of something done to their hair. Michael is his own barber, so unfortunately he can't fit in, which is why he's on the other side of the table. We're sorry, Michael, but one day you'll join us.
You're not, but don't worry. This is what it feels like. I'm attempting to be normal. I'm not doing a good job. One day I'll stop.
So, welcome everyone.
Thank you.
Winston, you're a creator. So, Michael, you're a creator.
Uh-huh.
I am a creator.
Yep.
And I'm sure a lot of our listeners have created stuff with or without their own, knowledge. Something could be something very random, like a picture that you took of the sunset. And to you, it's just mundane, just a picture. You used your smartphone to take and you posted it online. Next thing you know, a news website, which is monetizing its website, has used your picture to illustrate sunsets and they're making money off it. The question is, are you entitled to some of that money? Do you know what you should do about that creating that you just did? Do you know? Okay, send a message if you're a creator or if you've ever created anything or very, very interested in this conversation. 055 111 Let's start a conversation and join us. Send us all your questions about this as you listen to us. 055 111 055 11 Somewhere along the line, we might open the phone lines if we have enough time because I feel it's going to be a very, very full conversation, especially for me.
I was going to say, because I was going to put it out to the listeners that if you are an aspiring music maker, for example, and you've made a collection of soundtracks and a body related to physical activities, let's say sports.
Specifically
football.
It's football.
Popular sport.
Right.
Yeah. Say it's football, a worldwide body related to football takes your soundtracks
without your permission,
uses, and not just one, multiple soundtracks, uses them for all their promotional material, and then doesn't credit you, doesn't even nothing. What are your ways forward?
Yes, we will get there. First, we need to address what it is. Intellectual property. What does it mean? Initially, when I saw IP, in my line of work, IP is not IP. Intellectual property is your internet protocol. But in your line of work, Madam Sarah, it's intellectual property. So what is it?
All that you have described prior to this question is intellectual property. Your creativity. Intellectual property refers to creations of your mind. So when you create something, you have an intellectual property. The rights come in when the state grants you certain legal rights to that particular intellectual property. And those rights are exclusive rights to the use of that intellectual property. So when you have an intellectual property right, it means that nobody should be able to use the said intellectual property right without your consent.
Hmm.
And usually the consent occurs in the form of a license.
Okay.
The person would have to approach you for a license, and then the person will have to pay you maybe a lump sum or some royalties for the use of that intellectual property, right?
Wow.
So it's to exclude others from using your intellectual property without your consent.
Okay. So if I create anything, I don't even have to write my name on it. I don't even have to, let's say, get a certificate for it and say, this is mine. Once I created and I have proof that I created it, that's my intellectual property.
So there are two main types of intellectual property.
Right.
The copyright and related rights are what you have just spoken about, where you create something, you write something, literary and artistic works, you take a photograph, you have automatic protection for that. The moment the work is done, it's original, you have automatic protection for it. But when it comes to the second part of IP, where you call the industrial property rights, the patents, the trademarks, industrial designs, those rights have to be applied for. You have to apply for registration of those rights before you can enforce those rights. So it's not automatic that the moment you create, you create this microphone, come up with a phone, your software is under copyright, so you get automatic protection. But all other the designs, the bags, the cameras, you need to take steps to get them registered in order to be able to enforce your rights.
Right. So what we need to understand is that the physical stuff is the one that gets the patents, or it's not. It doesn't work like that.
Intellectual properties are usually intangible assets.
Okay.
They are creations of the mind, but you embody them in an object. For instance, this microphone, the idea of creating something that will amplify the sound that I'm making is what is protected as the patent.
Right.
So that is embodied in this microphone. So this is the product of that particular patent.
Makes sense. Makes sense. Okay. So why is it important?
It is important just as your other physical tangible assets are important to you. You have your car, you have your house, you have your land, and you won't allow anybody to just grab them without your consent. And that applies to the assets of your intellect as well. So if you have something and it's of value, most businesses these days, the intangible assets are even of more value than the tangible assets. So why would you not pay particular attention to the intangible assets and allow people to just take them away from you?
Right. So if I have an intellectual property, like I've come up with an idea or creation, what do I need to, what kind of strategy do I need to have? What do I need to plan the security of that idea before I roll it out, or I can bring it out to the market and then start, thinking of how to secure it later on?
Right from the generation of the intellectual property through to protection, commercialization, and enforcement has to be well planned. In generating the IP, for instance, if you want to invent something, some technology, if you want it to be of value, it means that it has to be new. How do you know it is new? How do you know there are some criteria. It has to be new. It must not be obvious to people skilled in the art, and it must not be just theoretical. It must be practical. So in order to make sure that what you have meets the requirement, you need to conduct your searches. You don't just, you have to conduct your searches in the patent databases. So at the end of your research, whatever you have come up with is original, it is new, it is patentable. And then having done that, you can then take steps to register and get the protection. And then you can think of commercializing. Which ways? How do you commercialize? So it has to work hand in hand with your business plan.
Right.
How do you want to market this particular product? How do you want to enter this market? So all those factors, are you going to go into a joint venture activity with an investor? Are you going to start a business around that particular product? Do you want to sell it, or do you just want to license it? Having done that, how do you want to enforce it on a particular market? Are you going to rely on ADR, alternative dispute resolution, a lot in that area, because maybe the information out there, it's so you wouldn't want it to be made public, because when you go through litigation it will be made public. So everything has to be planned.
Right.
Has to be planned. Yes.
So I have a very simple question. You
Yes,
mentioned
please.
business plans. Can business plans be protected under copyright? I ask this because I'm sure some of us have had our friends talk about this before, where they go to pitch an idea to a supposed investor. They go, they pitch everything, they give them as much information about how they're going to execute. So pretty much the entirety of the business plan is given to the investor. And then the investor is like, you know what, we don't like your idea. Try another time. And then months down the line, your exact business has been executed by said investor. Is that legal?
I've heard stories, lots of stories about this. Unfortunately, the copyright does not protect the idea in the document. It protects the presentation, the fixing that idea in a medium. So if you have a business plan and it is written in a particular format and then somebody goes to copy it, that's a copyright issue. But the idea in there is not what is protected.
Oh, wow.
That's where you have to think about your trade secrets, your NDAs, and so on and so forth.
So are trade secrets protected by copyright? So it's also an idea.
So trade secret is also on its own. Copyright is on its own. You have to patent on. Those are different tools of IP. So for trade secret, it is a secret that is protected because it is kept secret, and it has value because it has been kept secret.
Right.
So if you have this information and it has acquired value because you have kept it secret.
So like the Coca-Cola formula.
Yes.
Formula and the chicken from KFC.
That
recipe.
And spices.
Yes.
Right.
They have taken steps to keep secret. So you can even have your database of clients. You can keep that secret, and it has acquired value to acquire value as a result of that secret, secrecy around it. Yeah.
Right. So there's also the concern that IP rights can be expensive. For instance, if your rights are infringed and you want to basically proceed to sue whoever it is, it's expensive. What can I? Is it worth it if I can't afford to sue someone if my IP rights have been infringed?
You look at it from. Let's look at it from a different perspective. If you don't protect your IP, it means everybody can use it.
Right.
Everybody can commercialize it, and if you have investors who have more money, they will actually push you off the market.
Okay.
But if you protect it, you may even have investors supporting you to even sue. For because it has acquired that value because it is protected.
So how do I protect it?
So there are steps for protecting your IP depending on the type of IP.
Right.
We actually came up with a book, Monetizing Your Creativity. And in that book, we have actually stated step by step what you should do for all your IPRs, protecting your IPRs. IPRs generally are territorial in nature. So if you have protection in Ghana, doesn't necessarily mean you have protection in Togo.
Right.
Apart from copyright, which is automatic protection. But all the other IPRs that need to be registered before you get protection, you need to take steps. So if it's a local, if you want protection in Ghana and it's industrial property, maybe a patent, you need to go to the Registrar General's department. You fill the necessary form. You will supply the necessary documents that they would request for. And then if it's trademark, same applies to that. If industrial designs. And when it comes to the copyright, the fact that it's automatic protection doesn't mean that you shouldn't register. When you register it, it gives you some some kind of security, in the sense that you can just pull out the certificate to show as proof of ownership, and then the other party will now have to rebut that.
Right.
Yes.
Okay. So in this case, Michael was given an example. So assuming that the body that infringes on your rights is based overseas, and you registered it in Ghana, like you mentioned, that your rights in Ghana may not be extended into Togo, what do you do then?
So if you want to enforce your rights in other jurisdictions, you need to take steps to have them registered in those jurisdictions as well. So that's why you need to have a strategy, your IP strategy, for all your IPRs. If you know that, for instance, my rights will be infringed in Togo, next country, Benin, Nigeria, US, wherever, I will take steps to have them protected in those countries, so that when there's any infringement in those countries, I can quickly enforce my rights in those countries. But where you leave some jurisdictions free, what it means is that your IP will be within the public domain in those countries. And when your IP is in the public domain, it means that anybody can commercialize your IP.
Wow.
That's what it means.
Wow. Now, this sounds like every creator would have to take that responsibility of securing their rights in every single domain.
It depends on your market strategy. It depends on what you want. If you feel that your IPRs are likely to be infringed in jurisdiction A, and then maybe less in jurisdiction B, maybe you focus on jurisdiction A. So what you realize is that in our part of the world, Africa, you don't have many patents here. The foreign companies do not really register their patents here because they feel we will not infringe.
Yeah.
We don't have the capacity to infringe. So they would not even bother to register here. They would register in other jurisdictions.
So
yes,
it means that it's in the public domain here and
it
can be
is in the-
commercialized.
Yes, and we don't even commercialize them. So they are right in not registering here. Anyway, it's free here, but we don't commercialize. So yes,
Wait,
they
so
have every right not
if
to.
I get this right, I can basically recreate the washing machine in Ghana
Why not? If it's not protected here.
or
Why
the
not?
vacuum cleaner in Ghana
Why
and then
not?
be earning
Yes.
Wow.
Your V8 engine.
Yeah, my
Yeah.
V8 engine can actually be patented here if it's not registered
No, you
here.
can't patent it.
But
I
you
can't
can
patent
just
it, but I can commercialize
You
it.
can commercialize it because
Interesting.
to patent it, the invention must be new
Right.
globally. So long as it's been protected somewhere, you can protect it
Okay.
here. But you can commercialize it.
And I don't owe the person any
No,
royalties.
no,
So now you talked about jurisdictions.
yes.
Isn't there like some one random like international body that you can go to and be like, you know what, I'm patenting this here, so it has to be respected to a certain degree across board? Because it sounds like, and I have to go to Nigeria, find an IP lawyer, go through the process. Okay, we are good. Go to the next country. That's what it sounds like.
So to simplify this book on monetizing, we have it in our chapter 2. What steps you can take for registering in each country. So depending on the IP and reference, if for instance, if it is patent, we have some international legal documents, conventions, treaties, and so on that we are parties to. And the most common one is the Patent Cooperation Treaty, and that one is administered by the World Intellectual Property Organization. So with that, you can put in one application through the International Bureau of WIPO, and they would conduct their initial preliminary formality examination, and then when it comes to the substantive examination, they pass it on to the international search authorities, and then subsequently it comes back to the individual country. So it's just one application you put through to WIPO, and then they would then send it down to the individual countries for
right.
them to grant. similarly, if you have trademarks, we have the Madrid system. You can put in one application, but that one will have to start with from a basic mark. So you start from your country of origin, you get your basic mark from there, and then you convert it into a Madrid application, and then they will take over and send it to the various countries.
Right.
That sounds less tedious.
Yes, it does. And it begs the question that is this different for patents and copyrights and trademarks and
Trade secrets.
well, trade secrets not part of it. It's an idea. You haven't been learning. You can't register
Yeah,
an
you can
idea.
register an idea.
So that's one thing I've learned today, and I'm sure everybody's also learned. You can't register an idea because the idea is not original to only you. All right, but it's the execution of the idea.
The fixing of the idea in a medium.
Right.
But an idea in terms of patent, it is the idea of the inventor, which in practice is a solution to a problem in the field of technology. So
Right.
that idea as a patent can be protected.
Okay, so not the concept of the TV show that you had to
No.
present to someone
No.
or the presentation.
No.
Yeah.
No, that can. Okay, got it. So let's differentiate for people that don't understand intellectual property, trademarks, patents, and copyright. Because I've seen a lot of people confusing these four a lot. That my copyright, maybe what they're talking about, their patents or the trademark. It's very confusing. Winston, you want to say something? 'Cause you look very pensive.
I'm actually just listening.
Okay, so yes, let's explain all these four so everybody understands and knows when and where to use them.
So intellectual property deals with creations of the mind.
Right.
And it includes the trademark that you've mentioned, the copyright, the patent.
Right.
They are all intellectual properties.
Right.
Intellectual property rights,
Right.
actually. So under the intellectual property rights, you have the copyright and related rights, where you have your literary, artistic works, music, videos,
Okay.
even your software, computer programs fall under copyright. In the related rights, the producers, the broadcasters, the performers, they have related rights in the copyrighted work. Patents and trademarks, they are industrial properties.
Right.
Just the word is industrial properties related to business, industrial property.
Okay.
So your inventions, your anything, any product or a process that is new, it is not obvious to people skilled in the art, and it's industrially applicable, can be patented. Then the trademark is that Joy FM that you
logo.
have there, your logo there. It distinguishes Joy from other radio
Right.
businesses. So it distinguishes your service, in this case a service, from services of other enterprises. So that's a trademark.
Right. So someone can actually also infringe our intellectual property by using our trademark.
Yes, without your consent.
Without our consent.
But with your consent, yes.
Okay. Now that makes a lot of sense. Geek Squad is brought to you by MTN. MTN everywhere you go. We're going to take a quick commercial break. And when we come back, we're talking about intellectual property, and we are learning a lot. We'll be right back. And we're back. The show is Geek Squad on Joy FM. Your radio is tuned in to Joy 99.7 FM. And if you're watching us live on YouTube or Facebook, it's Joy 99.7 FM. We're live. Yeah, on TV. I mean, not on TV. It's on your TV if you're using your
Smart
streaming
TV.
it or smart TV, but it's on the radio. And if you are not going to be able to listen to this to the end, it's going to be available via podcast, Google Podcast, Apple Podcast, Spotify, and it's recorded on YouTube, so you can watch it afterwards. And you can watch our older episodes. You can listen to them, and you can always join our Telegram group, t.me/JoyGeekSquad, or you can tweet at us on Twitter, #JoyGeekSquad. So that's so many ways to keep enjoying the things you love on MTN. Just because everything is made simple just for you, on MTN you get to enjoy convenience when and anywhere you top up your MTN account. Just top up your credit by using mobile money or my MTN app. You can also purchase it from any vendor at the recommended retailer price and get a 100% bonus. Please remember to demand the same value. Retailers who do not comply will be sanctioned accordingly. It's super simple and convenient. That's why we're good together. MTN everywhere you go. And MTN is bringing you Geek Squad. Geek Squad is brought to you by MTN. We've got a few messages on WhatsApp. Send us your messages, your questions. We're talking about intellectual property, and we're going to start from the first one. Good topic for me. I'll start my content soon. I'm listening. That's Nana Kwesi. Okay, Nana Kwesi. And good evening, Geek Squad. I have a question. So Akosia asks me to take her some photo for a fee. After I submit the final work to her, I also use some of the photos on my company Instagram. She says I cannot use them, but I took the photos, and I believe the creative works is my intellectual property. Am I wrong? Very interesting.
This is actually a very good question.
Yeah, it is. Yes,
Answer?
please, you can.
Okay. So, yes, if you take a photograph, the IP rests with the person who took the photograph.
Okay.
But there's a caveat here.
Hmm.
If it is a commissioned work, if she was commissioned to do the work, the IP lies with the person who commissioned her to do the work.
Right. So,
The economic rights, there are two rights here in copyright. You have the moral and then the economic right. The moral right will remain with the person who created the work in perpetuity, but the economic rights can always shift. In this case, the commissioned work belongs to the person who commissioned the work.
okay. So, if I took a photo of Michael, he didn't commission me, but I just saw him, doing usual Michael stuff, and I took a photo of him. The IP rests with me.
Exactly.
What if he didn't give me permission to take a photo
So
of
those
him?
are others. You can talk about image rights and so on, privacy
Right.
rights and so on and so forth. But otherwise, when it comes to IP, you own the
I
IP
own the
to
rights.
the photograph.
Okay.
So
Here I
our
come.
producer actually is whispering a very important thing. So does that mean that paparazzi, what the paparazzi are doing, is right? I mean, when they take the photo, it's their intellectual property.
Yes, it is their intellectual property.
But you still have.
There are other rights that
Hmm.
can come to play, privacy and so on and so
But
forth.
the intellectual property
the
rests.
intellectual property rights rests with the
Which one is
paparazzi.
heavier?
Yeah,
Like,
because
which one-
you mentioned
It's
the
case
moral
by
and the
case.
Oh,
you mentioned
okay.
moral and economic, and it sounded like in certain cases the economic one, in this case, the questions case, the economic one outweighed the moral one.
The moral and the economic rights usually go together,
Mm,
but you can always assign the economic rights to somebody else.
okay.
In terms of the commissioned work, the commissioned work belongs to the person who commissioned.
Right.
Okay.
Okay. Got another question here from Kay in Wager. Good evening, Spiky. Please ask your guest for me. Who owns the rights to a software or a software feature? I built a software feature I built as a software engineer at the workplace or remotely using a workstation or computer provided by my employer. Also, please ask her what her thoughts are on the intern who worked on Spotify Wrapped and seemingly got nothing in return after it blew up.
Let me add a little more to this question. So there are certain companies, or there are certain tech companies where anything you create, even in your downtime, within the period where you are working with them, it's not yours apparently.
Yeah, I mean,
It's not
people don't
yours.
read the contract you signed.
No, it's not yours.
So if I use my personal laptop,
It's not yours. If you create something in the course of your employment, it belongs to your employer, unless there's a contract to the contrary.
wait,
That is what, at least the Ghana law is very certain on that. If you create something in the course of, so if you create something here in the course of employment and the Joy FM, it belongs to Joy FM.
So wait, does that include lunch break?
yeah, that's what I want to know. So if I am spending, the working hours are, let's say, from 9 to 6 p.m. and then after that I'm working on something personally.
Personal but related to your job.
Okay, so as long as there's a direct relation to your job, it
It
belongs.
will be a case by case basis, but it's most likely going to belong to your employer. But for instance, if I am a cleaner here at Joy FM and I create a camera that can capture from all angles at all times, that is not in the course of my employment. I was not employed to create cameras. I was employed as a cleaner, but if in the course of it I develop something.
So if you developed a vacuum cleaner while you were employed.
Yeah, it's related to my work.
Okay,
Yeah.
so this please, have you heard the story about the engineer at Vodacom who sued Vodacom in South Africa for his "Please Call Me Back" feature, and he's been asked. Vodacom has actually been asked to pay him lots of money for infringing on his intellectual property.
I can't speak to that because I don't know the details.
Right.
There could be, probably in his contract, there could be something in there that is to the effect that if he created something beyond a particular value, he was entitled to some percentage. So I cannot really speak to that. But the
Right.
general principle is that if you create something in the course of your employment, it will belong to your employer.
Cool. So we're going to be opening the phone lines in a few moments, so you can call and ask your questions about intellectual property. Meanwhile, so you know what, let's just open the phone lines. I'll just continue asking the questions, and so we've got another question here. Is there a question? Okay, no.
I think it's a
We're
follow-up.
going to keep our creativity till we fire our bosses. Really, I ain't creating it for some company to own it.
I have another question with that. So you mentioned that if whatever I create is not in line with whatever I'm being employed to do, but what if I didn't have a laptop? I don't have a personal laptop, and I make this said thing on my work laptop. What happens to that?
So it depends on the company's policy. Most companies are supposed to have IP policies, and all these are supposed to be stated clearly in the ownership rights, so created works and so on. But if you don't have that, it will be a case by case matter to be determined.
Right. So the phone lines to call 030-2216-541. 030-2216-541. And you can still send us WhatsApp messages on 055-111-997. 055-11-11-997. So what type of penalties could I incur if I infringe on someone else's intellectual property?
It depends. Again, depends on the value of what you have infringed on and the extent of
Does
the
anyone go to
infringement.
jail?
There's criminal and there's a civil aspect. So with the criminal aspect, if you counterfeit, if you pirate, you are likely to end up behind bars, or you
Right.
can have some penalties, some fines, and so on. But when the person takes the civil aspect, that's where you pay damages. You may be asked to even account for profit and so on. So there's a wide range of reliefs for infringed works.
Right.
Yes.
We've got a call on the line, Benjamin in Adenta. Hi, Benjamin.
Yeah, good evening. How are you?
Good evening, Ben. It's been a while.
Yeah, it's been a long time,
Yeah.
and I hope you're good.
I'm very well. How are you?
Okay, I'm good. I'm really fantastic.
Great.
Yeah, I couldn't join early, so maybe some of the things I may want to ask was covered. Pardon me if that was the case.
No problem.
I want to find out the processes or procedures through which somebody can register your intellectual property here in a part of the world, and how does that make it global? Do we have any such standards? Because people can patent things in America and you can't even do it anywhere else in the world. And then my other issue has to do with the software that we have. I mean, truth to be told, some of them codes are just copied here and there. Can people also, protect their codes regardless of the fact that probably you use C++ or Python or whatever programming language? Can you also patent that, or you can have that protected as your intellectual property? If that's the case, then what happens if you buy a software and later realizes that some of the codes apparently were not even originally from the guys or girls who actually gave it to you? Thank you.
Thank you very much for calling, Benjamin. So the first part of your question was covered, so you can listen on the podcast. But then let me plug in Madam Sarah's book. There's a book here, Monetize monetizing your creativity and innovation. It's an introduction to intellectual property. It has all the answers that you're looking for, and I think that everyone should grab it. I've already told them I'm grabbing one because at this point of TikToking and Instagramming and Facebooking and YouTubing, everybody needs to know how valuable your knowledge or your intellectual property is, and this book will be your first step to making your first million from your copyright. So if you missed that part of the conversation, get the book and then go read it. You get all full details. But Madam Sarah, if you want to touch on what the questions he asked a bit.
So the first question has to do with
registration yes.
of his patents in many jurisdictions, because registering in one country will not afford him protection in another country. So as I've already mentioned, there are procedures. You can register in one country by going to the competent institution to put in your application, or but if you want multiple jurisdictions, you can use the International Bureau of the World Intellectual Property Organization as a starting point. So that can addresses partially his question. And that second question has to do with the software and whether he can own some rights to use of certain source codes. I believe he's referring to some open source.
Some
open source source codes.
If I got him right, assuming you're using a software, you find out that there's bits of the code that was gotten from another software, regardless of the language it was written in. Let's say somebody just repurposes your code into their language.
It's very risky. It's very risky because I mentioned that software is protected by copyright.
Right.
So all those who have developed these source codes have copyrights to them. How they use the copyright will determine whether you can use it and modify their source code. So if you have somebody's source codes being given out as an open source, even with the open source, there are licenses attached to the open source. So if it says the open source is copyleft,
if
it says if it's copyleft, it means that when you modify the source code, you must also copyleft it. It means that you must also give it out for free and for anybody to modify it. So you cannot lay proprietary rights over it.
Okay.
There are some source codes with licenses that allows you to modify the source codes and still attach some proprietary rights to it. So you need to be very careful. You can obtain a source code which would have some proprietary source codes in there, and then you then infest it with your copyleft. So you need to be very careful.
Wow.
So what I gathered from this is read the terms and conditions.
Yes,
you definitely
read the
need to read
license. It's a copyrighted work. So read the license attached to your source code.
So that EULA, the end user license agreement.
Yes, read it.
You need to read it.
Yes.
Wow.
I just felt my brain expand.
I mean, if I had ever heard the word copyleft anywhere, I'd been like,
I thought it was
playing,
a pun.
Yeah, someone's playing games with me. You know how you say, "Oh, are you all right?" No, we are all left.
Yeah.
So can I go to any lawyer regarding the topic if they're suing to do? Like, can I go to any lawyer? Or it has to be an intellectual property lawyer?
It's always advisable to go to people who practice in that particular area, even though any lawyer could go and read about it and help you. But the advantage here is that IP lawyers practice IP.
Right.
So they may have the experience in that field. But otherwise, any lawyer could read and try to help you.
It's just like the way doctors have specialists.
Exactly.
So you can go to any doctor. He would, diagnose you, but you go to a specialist and they know exactly when it comes to which surgery you're supposed to. Okay. So good evening, Geek Squad. What's the difference between freeware and shareware? That's Big Show listening from Legon. Amasamai. Big Show in Amasamai. So freeware and shareware.
I think that one you have to explain it. Those
Yeah.
are not copyright words.
So
These are not IP words. So
Winston's the
if you
one
can-
who's been doing that kind of stuff. So
Me? Freeware.
No, so freeware is essentially software that is basically free. It's just like
Yeah.
open source software. Shareware is software that you can. It's not so. Freeware is like open source. It's free to
Okay.
use, free to share,
Yeah.
and free to even repurpose, depending
Yeah.
on which terms, depending on which license is
Yeah.
governing
Essentially, you're not charged to use
to
freeware.
use freeware. Yes.
Now, modification of freeware or getting the source code for that is up to the developer.
Yeah.
Some make it open source. That yes, you can take my source code. I'll just protect their source code, but yes, the software is available for free. I think with shareware, because shareware has really fallen off.
I think
It
Shareware-
can actually be paid software, but can be shared.
Yeah, I think shareware will probably fall in line with trial.
Yeah.
So you have a trial period where you can use it. So they are sharing it with you. We are like, oh, it's nice. You test it, try it out, and then when the time is up,
Elapses, you have to.
they're like, boss.
That's a freemium model.
Yeah.
Yeah.
So
Yeah.
shareware is most.
But you know, a
likely
lot
the-
of software
WinRAR.
is single user, so you
Yeah.
can't share your license.
Yes.
But with the shareware, you can share with other people. You can share your license with other people to use, and it's not illegal.
But most importantly, you need to look at the license.
Yes. So
You
you
need to
definitely
read
need to read
the
the license.
license.
I mean, we've spoken a lot of times about not reading terms and conditions and licenses and all the agreements.
I agree.
We're always quick to click. I agree.
You know what's even more interesting about clicking I agree is that the GDPR from the EU actually went on a limb to force companies to make it shorter. And recently I look at it, I'm like, is this really the shorter you guys are talking about? And then I think about it, I'm like, it's probably a lot of legal jargon that
Yeah.
needs to be said the exact same way. Other than that, it doesn't apply.
So, Spiky, I'm interested in a book authored by a guest. I'd be grateful if you could tweet it plus details on where I can order or pick up a copy. Sure, I would do that, but I'll let Madam Sarah tell you where you can get a copy or where you can order from.
Yes. So for now, we have copies at EPP,
Okay.
Bookshop, and then Book Knock as well. We are trying to get it at Kingdom
Right.
as well. Otherwise, we also sell it online from our own website.
Right.
And our website is www.ankoatlaw.com. So you can get it from there, or you can call any of our numbers from the website.
Right.
I can also give my personal number if
Sure.
that's okay.
Yeah, you sure you want to do that?
Well, if you're
With,
willing to receive.
office number.
Oh, yeah,
Okay.
yes.
Have
No, by all means do.
I have to get the office number then.
So it's ankuatlaw.com. Go to
Yes.
Anku, ANKUAT law,
Yeah.
LAW.com.
For, you know,
Yes.
for a second, I thought the
It was
at
at symbol,
the
yeah.
at
That's why I had to
symbol.
clarify.
Okay.
So Anku, ANKU at. It's not an at symbol, it's AT law, LAW.com. And you can order the book online. Please, when you buy the book online, don't be sharing it. If
Let
you
them
read
also
the
buy.
agreements, it's one person,
use
one book. Don't share. Let other people also buy. So because a lot of knowledge in there and has to be shared. And publishing is not cheap. And it's an intellectual property in there.
Yes.
Right, so don't infringe on it. And yeah, you guys have any questions to add before I go back to social media to go read the questions we have?
I mean, I'm just curious about. So, I remember earlier on she said, Sarah mentioned that because copyrights for, let's say, international things haven't been registered here, well, symbols, icons, music, whatever, they haven't been registered here, so we can use them. See, he's nodding their head, so I got that very wrong. So,
So the copyright, I said, is automatic rights. So whether it's created in US, in Egypt, in Ghana, it is automatically protected. So you cannot use without the consent of the author. When it comes to patents, the industrial properties, the patents, the trademarks, the industrial designs, if they are not protected, in a particular jurisdiction, it means those rights have fallen within the public domain within that jurisdiction, and you can commercialize.
Right.
Okay, so I have a question. Now, what if I made a song, right? And I'm like, you know what? Let me put it on YouTube, make it free, non-copyright music. Yeah, it's free. And then years down the line, I'm like, you know what? I want to can I switch it? Can I take it away from being a free property? And then if I can do that, what happens to the people who use it under the presumption that it was free?
It is your right. You can choose to exploit it the way you want. If you choose to make it free, that's fine. Within the period that it's free, then anybody would use it. But if at a point you decide to commercialize it, then that is also your right. So if at that point somebody decides to use it for free, you can take steps. It's a case by case basis.
Okay. So what about the people who, let's say for instance on YouTube, like I was saying, YouTube, everybody can use it. YouTube has an AI that runs through to check the copyright stuff. And then later I tell YouTube that, you know what, I want to commercialize this. Does it penalize the people who used it in the past?
No, because in the past you gave it out for free.
And they have the license to use it for free.
Okay.
Now, mentioning YouTube, we have very little time, but please, can you touch on fair use? Because I know there's something in copyright or intellectual property law called fair use. What is it, and what are the limits of fair use?
How fair is it?
So again, it's a case by case basis. There are limits especially in terms of copyright, so that we don't limit the information that goes out there. You need information for education purposes. You need information to bring out other information. So if we say everything is copyrighted and cannot be used, then we are limiting the flow of information as well. So the fair is relative to the quantity or the percentage of what you are using. So if you have a book and you copy 50%, that's not fair use. That is not fair use. And if you use it for commercial purposes, is that fair use? That's not fair use. So it depends on what you are using the work for, what the law says, and it's usually defined by the laws of that particular country.
Right. So I've seen on YouTube that you can use about 15 seconds of certain content under the fair use. So beyond 15 seconds, no longer fair use.
And I've also seen situations where now YouTube has a lot of social commentary,
right,
where people take videos and then they play the video, watch it, pause, and then
give a reaction.
And apparently there was a time where a certain YouTube channel was trying to copyright strike other content creators, and it backfired on them to the point where their channel was actually blocked. And what I heard was that it was fair use because the new creators took that content and transformed it into something else. The mere fact that they had social commentary over it, that's apparently what the YouTube standard is. So what's up?
Adaptation is also the right of the copyright holder. Modification, reproduction, distribution, all that is part of the bundle of rights that the copyright holder has.
Wow.
So you can't just adapt somebody's work and say you have adapted it, so it's fair use. No.
I think maybe then another thing most creators need to look at is YouTube's as a medium fair use policy, because I'm sure
and
that
their
is the
copyright
reason
policy as a whole.
because I'm sure that's the reason why these creators were able to modify it, because maybe YouTube is saying that, okay, if you are making this on my platform, these are the rules you need to play by. And is that acceptable?
It depends on the rules of the laws of the particular jurisdiction as well. So because all that we are talking about, the IP that we are talking about, they are governed by laws. So whatever the law says in a particular jurisdiction, that is what holds. So probably where their business is hosted or where they have their business, that's the YouTube, the law allows them to do ABCD under fair use.
Okay.
And that's what they have included in their licenses.
Right.
Okay.
Yeah.
Okay, so we're going to take our last commercial break, and when we come back, we're done. MTN everywhere you go. My name is Kobby Spiky Nkrumah. Thank you for joining us. Thank you, Madam Sarah, for being a part of us. And your book is a must read. Everyone who wants to know anything about monetizing your creativity and innovation, grab a copy. anku@law.com for more information. Thank you, Winston. Thank you, Michael, for joining me. And thank you to my producers, Prince Safo, for making this possible, and Dennis Fairboy and Abeku Sankofi for telling me my time is up. My name is Kobby Spiky Nkrumah. Thank you for giving me the pleasure of your time.